But, Mr. Deputy Speaker, we have some important business, and I'll be getting into that as we're debating this compendium of pieces of judicial legislation, which include the Judges' Remuneration and Pensions Amendment Bill, Court Services Bill, Supreme Court Amendment Bill, Court of Appeal Amendment Bill, Coroners Amendment Bill, and the Magistrates Amendment Bill. This morning, Mr. Deputy Speaker, after realizing that we are now back to business, having gone through the by-election process for West Grand Bahama and Bimini, I decided that I was going to do something a little bit different. And so while I was in the kitchen making my coffee, I put the television on to YouTube and I did a little 2-minute exercise, Mr. Deputy Speaker. You know, the battle may be over, Mr. Deputy Speaker, but the war has yet begun. Mr. Deputy Speaker, that said, it was my every intention as a new member of Parliament. I think the Attorney General has referred to me in the past as a rookie member of Parliament, but nevertheless, I would have come in the 2021 administration, and the victor, Mr. Kingsley Smith, would have also come in the same administration in a different year, but in the same administration. So we'd be all one and part of the same entry class, Mr. Deputy Speaker. I had every expectation of congratulating him and the Prime Minister in the House of Assembly today. It was my expectation that with his having been nominated as a candidate and been victorious, that he would be ready to do the people's business. Mr. Deputy Speaker, we went through the process of the parliamentary registrar returning the writ of election, but we don't have another member of Parliament in this House of Assembly. I'm not sure how this is supposed to work, and I don't hold Mr. Smith I don't even know if I should be calling him, well, I shouldn't be calling him West Grand Bahama and Bimini yet because he hasn't been sworn in. I don't believe it is his cause for not being here, but I also believe he does have a bank account. So what I do believe and what I don't believe as regards to the good gentleman is still too early to tell long term. But there have been, and I've counted at different points today, no more than 16 members of the government side coming here. 16 members is half of their complete side. They have 32, we have 7. That's a total of 39. Where is the other half of this Davis Cooper administration's government, Mr. Deputy Speaker? And where and why does West Grand Bahama and Bimini still not have representation in the House of Assembly? Now, I understand that a contingent has gone to Dubai. We must have timeshares in Dubai, Mr. Deputy Speaker, because we seem to have a commitment to go there every year. And it's not just one group that goes, it's more than 2 groups that go. So it's probably a 2-week timeshare that we have down there in Dubai, Mr. Deputy Speaker. I know that from the Middle East, we've gotten a $70 million loan that's supposed to be going to the Exuma Airport or to multiple airports. I've not seen any airport work yet in this great Commonwealth of the Bahamas that this administration can take full accountability for, except for a few used containers being remodeled and modified for North Eleuthera. The South Eleuthera, Central Eleuthera Airport, Mr. Deputy Speaker, still is an extreme eyesore. It's in the same state of condition that appeared to be the government's political party's headquarters in West Grand Bahama, where the roof was caving in and the paint was falling off the walls. But this is where we are, Mr. Deputy Speaker. The opposition is here. Half of the government is here. The other half is, as I said, in their timeshare in Dubai. Mr. Deputy Speaker, in preparing for this compendium of bills today, I thought it an opportunity to pique an interest. I went through a bit of the minutiae of each of the bills. And when you're looking at bills that are, for the most part, amendments, you can't just look at the amendment bill itself. You have to look at the original bill that it's amending. So while I do support these bills, Mr. Deputy Speaker, I want to make sure that through this debate process, we get amendments right, Mr. Deputy Speaker. We all know that the court services bill is something that the late Chief Justice Brian Murray had fought very long for. The former Chief Justice, Sir Brian Murray, had fought very long for, and I know that probably the entire time that I've been an attorney at the bar, it's been something that has always been at the forefront of the future plans for our judiciary to have more independence from the executive, as it's our third or second branch of government. Mr. Deputy Speaker, curiously, in trying to review the original legislation to compare the amendments, I went to the Laws of the Bahamas online statutes, and I've looked at that site for probably the last 10 years, really since it came into existence. It did away with the books that you would cut and paste physical paper and stick in an update. And the site itself, Mr. Deputy Speaker, just a point of curiosity, appears to have been updated since June or July of this year, and maybe it's been released to the public even more recently than June or July of this year. But it's got some very attractive photographs of the Bahamas, almost as though it's marketing the jurisdiction. There's a beautiful one of the court complex. There's a beautiful one of a beach with some residential properties in the background. And then there's one of Government House, Mr. Deputy Speaker, where our Governor General resides and where a lot of our official functions occur. But curiously for me, Mr. Deputy Speaker, was the image of Government House had Columbus in it. And I don't recall any notification coming around or ceremony coming around for the re-erection of the Columbus statue there at Government House. But it's still at the forefront of the latest positions and websites of this government. Maybe at some point, as we get through this debate today, we'll hear when that statue is going to go up again. And I know that my counterpart, former boss Freetown, has an opinion on the person that should go there. I don't think the name should be announced in the House of Assembly of who that person is. But if we're advertising it, many Bahamians want it back up. Let's put it back up. If we're not putting it back up, let's still reconsider that. But if we're not putting it back up, take it off the site. Mr. Deputy Speaker, I'm going to begin my review of the compendium of legislation by looking at the Judges' Remuneration and Pensions Amendment Bill of 2023. Mr. Deputy Speaker, this is an amendment that amends only one section of the existing Act. The existing Act provided for retirement ages of 60 and 65 with pensions and gratuities. And this act seems to be addressing, this amendment bill seems to be addressing the particular section, and it identifies that notwithstanding anything contained in this section, the holder of a judicial office may retire and shall be paid a pension and gratuity in accordance with this act. A, at any time after attaining the age of 55 years, and B, having held judicial office for 5 years or more. Now, Mr. Deputy Speaker, there was a provision in the existing Act before this amendment that allowed judicial officers to retire at the age of 55. So initially, I wasn't sure why we were making this amendment, Mr. Deputy Speaker, why it was important to create a retirement age of 55 under this 2023 bill, when by Section 6, subsection 3 of the existing Act, it reads, notwithstanding anything contained in this section, any holder of a judicial office under this section may retire at any time after attaining the age of 55 years or having held judicial office for 5 years. So it seemed to be covered already. I haven't heard exactly why we're making an amendment to that bill when 55 was already an optional retirement age. And it may be to do with the language that continues in this proposed amendment. where it reads at 4, the new section 4 will read, nothing in subsection 3 shall affect the payment of a pension and gratuity previously made under this Act to the holder of a judicial office, or B, prevent the retirement of the holder of a judicial office and the payment of a gratuity or pension and a gratuity under this Act who is desirous of retiring in accordance with the provisions of the repealed Section 3, provided he, within 3 months of commencement of the subsection, indicates in writing to the Chief Justice his intention to retire in accordance therewith. So under the existing legislation, you can retire if you were serving when this Act came into effect at the age of 60 years. After that, the retirement age for you to receive a pension gratuity by Section B would have been at 65 years of age. In each case, at 60 years of age, if you were serving when this Act came into effect, which was in 1988, or at 65 years, if you were coming in as a judicial officer after this Act came into effect. Both of those provisions dealing with retirement at 60 or retirement at 65 clearly speak to the provision of a pension and gratuity. The provision in the existing legislation that I mentioned earlier, which talks about retiring at 55, a judicial officer may retire at 55 after having held office for 5 years. It doesn't specifically say that if you retire at 55, which is the third option of the current Act, that you'll get your pension and gratuities. So there's two things with the second part of this amendment. The first thing is how it says, notwithstanding in subsection 3, nothing in subsection 3 shall affect the payment of a pension or gratuity previously made under this Act to the holder of a judicial office. So this section is giving the power, which I said already existed, to retire at 55 once you've served 5 years in office. The current Act didn't allow you, or didn't specifically make clear that you would receive pension and gratuity. The first part of Section 4, Section 4A, nothing in subsection 3 shall affect the payment of a pension and gratuity previously made under this Act to the holder of a judicial office. So what I'm wondering, Mr. Deputy Speaker, is whether this provision is attempting to bless retroactively the disbursement of pensions and gratuities to persons under the 1988 legislation who retired after attaining the age of 85 but hadn't gotten to the age of 60 or to the age of 65. So there is, for me, Mr. Deputy Speaker, something that is not entirely clear. And if it is the intention that it's trying to make the retroactive payment of pensions and gratuities to persons that previously retired under the 1980 Act after attaining the age of 5 and having served 5 years in office, I think the language needs to be more clear. And if it's not trying to do that, Mr. Deputy Speaker, I would like to know whether or not there have been any individuals who retired at the age of 55 that have received pensions and gratuity. And Mr. Deputy Speaker, that then leaves just this last part of the Judge's Remuneration Bill, and that is where those who are desirous of retiring in accordance with the provisions of the repealed subsection 3 have to provide 3 months' notice from the commencement of the subsection. So the ability to continue to serve until the age of 65 remains. I don't understand what or who might need to serve this notice, because 65 was getting pensions and gratuities, 55 possibly not, but who's going to want to retire coming up on the age of 55 and give notice that I want to retire, I don't want my pension and gratuity? It's a little curious, Mr. Deputy Speaker, and maybe the drafting minds can just consider that to make sure that nothing is being missed, particularly the retroactive payment of any previous pensions and gratuities. Mr. Deputy Speaker, I'm going to move on now to the Court Services Bill. The Court Services Bill, as was acknowledged by my good constituent, the member from Fort Charlotte, a former Attorney General. This was something that was tabled under the last administration, Mr. Deputy Speaker.
As the honourable member for Freetown.
For Fort Charlotte didn't acknowledge that, and that is not factually accurate. A court services bill, 90% the same as this one, was tabled in the last administration.
Thank you, honourable member.
I believe that's what I said, but nevertheless, I agree with that statement. A court services bill was tabled in the last administration, and it was, maybe the percentages are off, 90% the same. Mr. Deputy Speaker, I in fact have a copy of that court services bill from 2020, and I have a copy of the current court services bill that we're now debating, that's in the year 2023. Mr. Deputy Speaker, when you look at these pieces of legislation, the beginning of the Act, you'll have the arrangements of sections. And when I take my ruler and compare, Mr. Deputy Speaker, the arrangement of these sections, Section 1 is the same, Section 2 is the same, Section 3 is the same, Section 4 is the same, Section 5 is the same, 6 is the same, 7 is the same, 8 is the same, 9 is the same, 10 is the same, 11 is almost the same, 2020 said long-term 2020 said long-term fiscal policy objectives of the Council, and 2023 says fiscal policy objective plan of the Council. Mr. Deputy Speaker, I'm going to go through. 12 is the same. 13 is the same. 14 is different because it says it provides qualifications of Chief Executive Officer, basically a qualified accountant. Then 15, Mr. Deputy Speaker, exists at 18 in the current legislation. 16 exists, 17 exists. Mr. Deputy Speaker, it's almost word for word what was done in 2020, and there's nothing wrong with that because this isn't about elected members of the legislature, Mr. Deputy Speaker. This is about the judicial branch of our government. This is about moving that independent body into a more empowered position, Mr. Deputy Speaker. And I want to thank the persons that worked on the 2020 legislation, including the former Attorney General Brian Sims, as well as the former members of Cabinet, Mr. Deputy Speaker. And I want to thank, on behalf of the judiciary, members of the Bar Association. I'm actually going to touch on the Bar Association because they appear to be left off of the board. Left off of the board, Mr. Deputy Speaker. I'm going to get to that. But it's essentially identical, Mr. Deputy Speaker. And this Davis Cooper administration continues to show how impressive they are when they can pick the low-hanging fruit that the F&M left in the full cupboards of a comprehensive legislative agenda. So, Mr. Deputy Speaker, as I continue, I'm going to put the 2020 bill down and just refer to the 2023 bill, Mr. Deputy Speaker. I'm going to now look at particular sections that are of interest to members of the public as well as to those debating the bill in the House today. My first point, Mr. Deputy Speaker, of note for the member for Freetown is in the Section 3 interpretation, particularly the first and second definition. The first definition reads board. It says means the board of directors of the council. The second definition is chairman, and it reads means the chairman of the board of the council. So I would suggest, Mr. Deputy Speaker, that an amendment be made to delete of the council in the definition of chairman. We know what the board is. We have a board of directors of the council. We don't need a chairman of the board of the council because the board of the council is not defined. It's necessarily repetitive and can make it confusing. Mr. Deputy Speaker, it then goes on in Section 3 in the interpretation to the courts. So courts, Mr. Deputy Speaker, means the Court of Appeal, the Supreme Court, the Magistrates Court, and the Coroners Court, and any other court declared by order of the Chief Justice. Now, when the good member for Centerville was the Minister of State for Legal Affairs, I recall him talking about these specialty courts, Mr. Deputy Speaker. That probably was at least over a year ago, probably during the 2022 budget communication, expectations, or even an independent communication by the minister at the time. Why, after such time has passed since then, do we not also list not only the specialty courts that the Minister of State, member for Centerville, had identified, but why aren't we also listing the specialty courts that were identified by the current Attorney General, Minister of Legal Affairs, Ryan Pinder? Mr. Deputy Speaker, the member for Centerville, former Minister of State, brought them up. The Attorney General, member, the Minister of Legal Affairs in the Senate brought these up. What they've identified at the announcement of this new court complex in the former Rodney Bain building, which is going to go into a specific purpose vehicle for the benefit of a massive court complex, all-inclusive court complex. There was expectation, Mr. Deputy Speaker, in those announcements by both Centerville and the Minister of Legal Affairs that there will be specialty courts for juvenile offenses. There will be specialty courts for sexual offenses. There will be a specialty family court, and there will be a specialty commercial court. Now, Mr. Deputy Speaker, if we're truly...
The chair recognizes the honourable member for Freetown.
There are magistrates' courts and Supreme Courts set for those purposes. In this country, we have two classes of courts, Magistrates' Court, Supreme Court, three really, and the Court of Appeal, who sit here. The Family Court is a Magistrates' Court, a Supreme Court. The Juvenile Court is a Magistrates' Court. The Commercial Court is a Supreme Court. I know Finance does more transactional work as a litigator. I can help him that all of the courts here are either magistrates' courts or Supreme Courts.
Thank you, honourable member.
Tell Finance that.
So, Mr. Deputy Speaker, there is something that most lawyers understand is an important quality to cross-examining, and that is you never ask a question you don't know the answer to. So the good member from Freetown has just stood up after I said there is no specialty courts because the big announcement by Centerville and the big announcement by the Minister of Legal Affairs that these would be coming. But then Freetown stood up and said they already exist. So, Mr. Deputy Speaker, I'll leave that right there. Two sides of the same cabinet are saying they're going to be bringing it. One said it's already been brung. I agree with you, Freetown. They've already been brung. But they've not been mentioned in this legislation, Mr. Deputy Speaker. So there isn't a cohesive plan to this government administration.
The chair recognizes the honourable member for Freetown.
The doctor knows what types of courts there are. The Act is very clear. It defines courts as magistrates' courts, Supreme Courts. The proposed family court complex, which is coming, will be a magistrates' court and a Supreme Court when it arrives. It's a simple matter of analysis. It's not very difficult. Even a doctor gets it.
Thank you, honourable member.
That's very good, Mr. Deputy Speaker. Now, I don't know why, with all the buildings around, I don't back down from my previous point. I think I made it clear. But now we're talking about when it arrives. And the good member from Freetown and the good Minister of Legal Affairs talking about the Rodney Bain building where these specialty courts are either going to be built or they're going to go in or they already exist or they're going to be placed. You have, Mr. Deputy Speaker, you have a completion period from commencement of construction of between 2 years and 2.5 years. The good F&M, Free National Movement Party, will be back in government by then, and I'll be there for the plaque ceremony. But more importantly, as was the plan of these guys that are sowing this complex, Mr. Deputy Speaker. It is the people of the Bahamas, if they see this through, Mr. Deputy Speaker, that will reap the benefits of these specialty courts. My only point, Mr. Deputy Speaker, is that as we're moving forward with a court services bill that identifies the particular courts, we don't have the specialty courts mentioned. Let's move forward with gusto, Mr. Deputy Speaker. If we can book first-class flights to Dubai, let's get these specialty courts built. Let's get them put into buildings that currently exist. Let's do this for the Bahamian people, Mr. Deputy Speaker. Now, Mr. Deputy Speaker, I'm going to put down this article by the Minister of Legal Affairs, and I'm going to go now, Mr. Deputy Speaker, just to give some examples of what this court services bill will do and the powers. There shall be established a body to be known as the Court Services Council, which shall be responsible for the providing administration and support services for the courts. The council shall be a body corporate with perpetual succession, a common seal. It may acquire, hold, and dispose of real property, Mr. Deputy Speaker. It may sue, it may put Mr. Deputy Speaker in its corporate name. It may enter into contracts and establish and operate bank accounts, Mr. Deputy Speaker. The board shall be the governing body of the council and shall perform the functions and exercise the powers of the council. Mr. Deputy Speaker, one of the things that the board is going to have responsibility for is the defraying by Section 8, defraying of the following expenditures. There's a few of them, but one of importance is, and again, the curious wording in this existing draft. The funds of the council shall be applied to defray the following expenditure. A, the salaries, allowances, pensions, and gratuities to justices of the Supreme Court and Court of Appeal pursuant to the Judges' Remuneration and Pensions Act. I've already spoken about the amendment to that act earlier. But essentially, money is going to be coming to pay the salaries of justices from the council. Now, Mr. Deputy Speaker, in this act at Section 19, Mr. Deputy Speaker, there is a provision in here that I didn't find in the 2020 draft. Section 19 says, judicial officers, not staff. 1, for the avoidance of doubt, except for the purposes of receiving salaries, allowances, pensions, and gratuities in accordance with Section 8, judicial officers are not staff of the council. I have not, in my personal experience, come into a situation where somebody was employed by one person but being paid by another person. Generally, who you get paid by, that's your compensation. That's the consideration for the services you rendered. But, Mr. Deputy Speaker, it's been added into this bill. Now, Mr. Deputy Speaker, also I want to bring the public's attention to my 5th point, which is on page 12. Mr. Deputy Speaker, on page 12, you're going to have pension for staff of the council. So in section 23, which is on page 12, you have pension for the staff of the council. The council shall establish and maintain contributing pension plans in which employee and council are responsible for making contributions. So this is an employee and council responsibility. Button B, the council shall establish and maintain a non-contributing pension plan for public officers who held pensionable offices under the government of the Bahamas and were transferred in accordance with Section 20 from the public service to the council. That's referred to as the benefits plan. What I can see happening here is that persons that have been working in the public service before can continue to participate in a benefits plan, a pension plan that the government is paying into. But new hires, Mr. Deputy Speaker, if you haven't been in the service of the government and transferred over into the council before, new hires are going to be subject to a contribution plan where the employer and the council, where the employee and the council are contributing. We've seen this recently with the Royal Bahamas Police Force incoming officers, Mr. Deputy Speaker. This is an interesting development by this caring Davis Cooper administration. Mr. Deputy Speaker, if I can, I would ask for 10 more minutes, but I see I have approximately 2. So I'm going to wrap up my points on this court services bill, Mr. Deputy Speaker, where I'm looking at the constitution of the Board of Directors. So the board of directors is going to have members, Mr. Deputy Speaker, and those members shall consist of the Chief Justice, President of the Court of Appeal, a Justice of the Supreme Court, the Registrar of the Supreme Court, who shall be the Secretary, the Chief Magistrate, a public accountant licensed by the Bahamas Institute of Chartered Accountants, a member of civil society appointed by the Chief Justice, and then, as Freetown was saying, the President or Vice President of the Bahamas Bar Association. So what's interesting to me is that you're going to have a public accountant, and I think that's probably going to be the Chief Financial Officer under this court services bill. Okay, it may not be, but you also have this position of a member of civil society appointed by the Chief Justice. Is that going to be the same individual who is going to be the Chief Executive Officer? So you're going to end up with a board that has no contribution from the Chief Executive Officer that has the authority over the administration of our Court of Appeal, our Supreme Court, and our Magistrates Court, and our Coroners Court. But they're not going to be sitting on the board, Mr. Deputy Speaker. Now, qualifications of the Chief Executive Officer don't make this individual having to need a background in law, Mr. Deputy Speaker. I am going to ask for 1 minute over my time, sir, if that's fine. And I say it's interesting because you have this Chief Executive Officer who basically is going to have all of the administrative functions usurped from the current administrating officers to him or her. Hopefully it's a her, Mr. Deputy Speaker, since we're in this week of honoring women in our country. But under Section 17, the administrative functions of the registrars under the Court of Appeal Act, the Supreme Court Act, the Chief Magistrate and Administrators under the Magistrates Act, and the Coroner and Administrators under the Coroners Act shall be vested in the Chief Executive Officer. You have the Supreme Court Act, Mr. Deputy Speaker, which intended and does increase the number of judges from 20 to 25 to deal with the court backlog, to deal with these specialty courts when this administration found them. But it didn't go so far as to confirm that the powers of the registrar by Section 65, 67, and 68 are seconded to the Chief Executive Officer. That, however, Mr. Deputy Speaker, was done under the Court of Appeal Amendment Bill. The administrative and financial powers, authorities, and duties of the registrar of the Court of Appeal are removed from the registrar, and they're to be the functions of the Chief Executive Officer under the Court Services Act. Similarly, in the Coroner's Amendment Bill, the administrator of the Coroner's Court, his administration functions will now be the administration functions of the Chief Executive Officer. The Court of Appeals registrar is now essentially going to be working for the Chief Executive Officer. The administrator, deputy administrator, assistant administrators of the Magistrates Court are now going to be, as far as administration is concerned, the assistants of the Chief Executive Officer. That is in fact what is being stated in the Magistrates Act. Now, finally,
you wrap it up.
Yes, I am. Finally, one more point for time to take into consideration is this, just as the leader of government business, you'll be putting these bills forward. But when you look at the amendment in the Magistrates Amendment Bill, I said I agree with these amendments, but I just want to make sure we get them right, Mr. Deputy Speaker. Section 2, it says the Principal Act is amended by deleting Section 4 and substituting the following. 4, Administrator, Deputy Administrator, and Assistant Administrator. 1, Section 1, the Administrator, Deputy Administrator, and Assistant Administrator of the Magistrates Court and such other officers are attached to the Office of Administrator shall assist the Chief Executive Officer. One important provision, Mr. Deputy Speaker, which I think should have continued, is that the first provision of Section 4 in the current Act is not replaced by this amendment. And that was where the Governor General under the Public Service Bill had the authority to appoint administrators, deputy administrators, and assistant administrators. So if we're removing that because we've got a new Section 4 and we're not inserting the new power by which these officers will be appointed, I'd like the government to ensure that they've thought that through and they know how it's going to be done. Otherwise, a slight amendment comes in to preserve the existing subsection 1, section 4. If they're not going to be public servants, are they appointed by the Court Services Council? It didn't refer to those positions under the Act. Mr. Deputy Speaker, I'm just going to close now, Mr. Deputy Speaker, as we're honoring National Women's Day. I've always struggled to look across the aisle and take in the images that sit before me, but I understand the Zonta Club, Mr. Deputy Speaker, has been in here, and they beautified the well today. And before my eyes gaze upon them, there are these beautiful orange bows, Mr. Deputy Speaker, that soften what I have to look upon. Mr. Deputy Speaker, we always talk once a year about the suffragist movement, the great women that have served in the Assembly, but I think that we need to do more than talk. As we leave one year, we set a target for what we're going to accomplish the next year. The women of this country are wondering where the $500,000 women's shelter is. Mr. Deputy Speaker, there are several other issues, Mr. Deputy Speaker. But I'm going to close now. Our Senator Maxine Seymour had a great letter to the editor in the Tribune on the 27th of November. It was penned by her on the 26th of November. It's worth getting a copy if you haven't already done so, Mr. Deputy Speaker. Maybe display it in your constituency office in North Eleuthera. But in closing, Mr. Deputy Speaker, we heard from some of the members of government, the female members of government today, and I'd just like to acknowledge all of the women that were candidates in the last election for the Free National Movement for their continued contribution to the success of civil society in this country, governance, being role models. One was actually inducted into the Sports and Athletic Hall of Fame, Garden Hills, recently. But those members are Pakeisha Parker Edgecombe, Miriam Reckley Emanuel, Jennifer Isaacs Dotson, Maxine Seymour, Nicole Martin, Vandia Stewart, Felicia Knowles, and now in this administration we have another female leader in the Senate, and that is the one and only Senator Michaela Barnett. Mr. Deputy Speaker, with that I close. Thank you very much for your time. Members of government, continue to try to do better. If you fail, the opposition will here to do best.
Thank you, Honourable Member. As many? Yeah. The Chair recognizes the Honourable Member.